And now I will introduce today's speakers. Kevin Slaughter is a partner in our business law group who assists businesses with complex commercial transactions. Kevin has extensive experience drafting and negotiating a variety of commercial agreements, development and licensing agreements, and manufacturing agreements. Kevin also represents clients in connection with M&A transactions with typical transaction values from $2 to $300 million. Tiffany Presley is also a member of our business law group and focuses her practice on commercial contracts, M&A, joint ventures, corporate governance and compliance, general corporate strategic advice, and a range of real estate legal services. She also has experience assisting multinational and tax-exempt clients with various tax matters. And now I will turn it over to Kevin and Tiffany.
Hello, everyone. Thanks for joining us. Again, the topic of the CLE is identifying and managing risk in supply chain agreements. The first thing I want to say is that we're going to cover three of the most heavily negotiated provisions in supply chain agreements: warranty, indemnification, and limitation of liability. This is only intended to be a general overview. I could easily talk for an hour for each of these topics. So again, just a general overview. It's not meant to be exhaustive. The other thing is that we're really not referring to the laws of any particular jurisdiction. We're really kind of referring on the general legal concepts related to these issues. And again, the primary focus of this discussion will be the allocation of risk between the parties and the different considerations that that business folks and lawyers need to consider as they engage in negotiations. So again, our agenda, the first thing we're going to cover is going to be a brief discussion of damages, which I think is important before we jump into the discrete subject matter, just to kind of set the context of what we're talking about and what the range of exposure contracting parties might face. And then we'll have a discussion concerning indemnification, move on to warranty, limitation of liability, and then reserve some time for Q&A at the end.
Okay. First, we just want to identify some of the common agreements that you see in supply chain operations. The primary agreements that Kevin and I deal with in assisting our supply chain clients are supply agreements, master services agreements, transportation agreements, distribution agreements, and license agreements. These agreements outline the terms controlling the supply of goods and services between various parties. You'll certainly come across a variety of other agreements. Some are industry specific, et cetera, but these are the primary agreements that we see. We want to start by taking a look at the three types of damages that result from a breach of contract. The most common damages in commercial agreements include direct damages, consequential damages, and incidental damages. Direct damages is simply the cost of a party getting what it's supposed to get under the agreement had the other party not breached. These damages they are the proximate result of a breach and include the losses that flow naturally from the breach. Then we have consequential damages. These are those that are beyond direct damages, and unlike direct damages, consequential damages do require an understanding of the specific facts and circumstances of the transaction, including what the non-breaching party has at stake under the contract and the ramifications the non-breaching party will suffer in the event of a breach. In order to recover consequential damages, the damages must be the foreseeable result of an act. The agreement's value must be able to be determined with reasonable certainty, and the breach must be likely to be the substantial causal factor in the damages. Incidental damages are the costs and expenses incurred by the non-breaching party to avoid additional direct and consequential damages. So I'm going to read you a quick hypothetical so we can see how these kind of play out in practice. Manufacturer contracts to purchase made-to-order parts that it will incorporate into its own product to sell to its customer. Supplier knows that manufacturer needs the part by Monday in order to have the finished product to its customer by Tuesday. Supplier breaches supply contract by failing to deliver the made-to-order parts to manufacturer by the agreed-upon date. Manufacturer then buys the made-to-order parts from a different supplier at a higher price and had to pay for expedited shipping in an attempt to get the product to the customer on time. Supplier fails to get the product to customer, and customer cancels the order. The replacement costs of the made-to-order part are the direct damages. These were the costs to make the manufacturer whole under the agreement. The loss of profits from the canceled order constitutes the consequential damages. Supplier knew that manufacturer needed the made-to-order part by a certain day in order to incorporate the made-to-order part into its own product for sale to customers. And the expedited shipping cost constitutes the indirect damages, as these were the expenses incurred in an attempt to avoid the direct and consequential damages. And that's a brief look at damages.
And before we move on, just on consequential damages, I just want to point out that the consequential damages had to be contemplated in some form by the breaching party at the time that the contract is entered into, not to get too far in the weeds. But again, as we start talking about kind of identifying and managing risk later on in the discussion, you'll see how this kind of materializes itself in action, if you will. Okay, so moving to indemnification. So indemnification, by its nature, is an express agreement of allocation of risk between one party and another. Oftentimes, without the indemnification, there may not be a potential remedy or recovery for the party that was harmed, absent the indemnification. I know a lot of times lawyers might look at indemnification provision almost as if it's boilerplate, and I think that's the worst thing that you can do. Indemnification provisions are probably one of the most heavily negotiated provisions in any type of commercial agreement. And again, it's not a matter of just negotiating, I don't want to indemnify you, and you really have to the expertise of each party, the role of each party, to what extent, for example, a customer might be relying on the expertise or the areas of expertise of a supplier. Is it just kind of their technical expertise? Are they looking for their industry expertise? What's the proper allocation of risk? And I think that when these provisions are negotiated properly, it gives the parties an opportunity to effectively and meaningfully allocate the risk. A lot of times, as we'll discuss later on with some other topics, oftentimes the economic reality doesn't really match up with the exposure, if you will. For example, a service provider might be providing a service or a product that is of very little value to them, like the contract value itself might be de minimis compared to the overall expenditure. Indemnification is a good opportunity to kind of go back and readjust that risk allocation together with some of the other tools that we're going to talk about. Again, indemnification provisions properly used reduce the likelihood of litigation in determining who's at fault and who should make who whole, and provides a sense of predictability. As with this provision can be both unilateral or mutual. And again, the big risk here is aligning the indemnification with the commercial realities, especially where there is a big delta between the economic value and the overall exposure.
And now let's take a look at a sample unilateral indemnification provision. We've color-coded this to make it easy to see the parts that generally make up an indemnification provision. So the red represents our indemnifying party, and under our sample provision, it's the supplier, agrees to indemnify and hold harmless. The green language represents the indemnified parties, and here it's the purchaser, its customers, affiliates, subsidiaries, officers, directors, agents, and employees. From and against, and now we have the recoverable damages in blue, which includes all losses, costs, damages, or expenses, including reasonable attorney's fees, defined herein as losses. And the yellow language represents what we call the nexus phrase, arising out of or connected with. The nexus phrase links the damages to the covered event and dictates the degree to which the two must be related in order for the event to qualify for recovery. Resulting from. Again, this just indicates the degree to which the damages in covered events must be related. The purple language represents the covered event, and here it includes breach of agreement by the supplier, third-party infringement claims, product recalls, and death, injury, or property damage. What covered events are included here will vary based on the facts and circumstances of the transaction. As Kevin mentioned, you really want to tailor this so that it aligns with the facts and circumstances of your situation. The blue language represents a carve-out, what we call a carve-out. Our carve-out is relevant solely with respect to Romanet 4 here, and it accepts from indemnification the death, injury, and property damage caused by certain alterations to the product made by purchaser or its customer. It's a pretty typical indemnification language, but it should be, like Kevin said, you want to knead the dough and make sure this is heavily tailored to fit your particular situation.
Yeah. So again, so kind of looking at that standard provision, and then kind of taking the risk at the particular commercial transaction that you're working on, you know, again, kind of stepping back, that was a provision with everything under the sun in it that may or may not be appropriate to your particular transaction. In determining the risk to the supplier, oftentimes the buyer will ask a supplier to make something to spec, that it performs a particular function in a specified way, at a particular level, at a particular performance. And that seems pretty straightforward. At the same time, so to what extent is the buyer relying on the expertise of the manufacturer? Is it just their technical engineering experience? Do they expect them to identify potential intellectual property owned by other third parties that it might infringe upon? Are they looking to them for the supplier to come back and say, look, this is what you wanted to do, but if you do this, it causes some harm? The point of this is that as lawyers, it's our responsibility to talk to the business people and or our clients, who are ultimately our clients, and understand exactly kind of what the roles of each party are, to what extent each party is to use its expertise. Because depending, even though we may ask a supplier to make a particular part, but if our engineering team has kind of just made it and it's just simply build to print, maybe we share more of the indemnification, but we are completely just saying, hey, we've got this idea, go make it for us. In those particular situations, it's probably more appropriate for the supplier to take a larger allocation. Will the product, is it a component that will be incorporated into its end product? Will there be other components from other third parties that are combined with this? And if that's the case, to what extent should all of those third parties, including the customer, share in the allocation of risk? And again, you know, that concept is there, but there's no one general rule. You really need to understand how do they work together, you know, who did what in the design, and in a multitude of other considerations. In determining the risk to the buyer, again, generally we're looking at quality, condition, legality, that is conformance with rules and regulations. And again, the same test, or this somewhat of the same questions: to what extent is the customer is the customer relying on the supplier to reach these particular conditions, to ensure the quality, to ensure that it's safe, that the packaging is in conformance with the legal requirements. Again, in addition to the specific commercial context, we also need to look at factors such as industry standards, typical business practices, the idea of materiality qualifiers. We talked about the scope of the people who are covered by the indemnification. Does it just cover the customer, or does it cover the end user? And under what circumstances will they be covered by this indemnification? In short, in order to effectively negotiate these provisions, you need to anticipate the problems. You need to sort out the what ifs and who's responsible for the what ifs, and you know, kind of what that exposure is, and just kind of walk through it. Again, all of this is an exercise to ensure that the scope of the indemnification trues up with the commercial reality at hand. So again, in kind of in practice, if you will, recently Tiffany and I were working with a client. I'll give you two examples, like kind of on different considerations and different spectrums of this particular issue. We were representing a client that contracted with a consultancy, and the service to be provided were valuation services. They were asking for their entire real estate portfolio to be valued. The entire value of the portfolio was in excess of $1 billion. And our client in turn was going to use the valuation to procure real estate insurance coverage on the different parcels within the portfolio. When the consultancy sent over the initial draft of the services agreement, there was an exclusion for indemnification relating to the accuracy of the services or what have you. I can't remember the exact language, but that was the concept. The consultancy knew that our client intended to take the valuation and work with this insurance broker to procure the insurance. So if we can't rely on the numbers, what good is that? So after a round or two of negotiations, it was clear that we needed some form of indemnification to cover that. To a smaller amount, which again, because of this potential exposure, that particularly didn't pan out. I mean, we'll talk about more of that discrete example in the limitation of liability. And there was actually let me give you 3 examples. That was the wrong example, actually. The example I wanted to give you was, it was a consultancy for services, and actually the services provided dealt with the management of the health plan. But the services didn't directly relate to the actual administration of the plan. They were higher level, kind of best practices, things to consider. And the exclusion from indemnification dealt with any claim made by a participant in the plan against the consultancy in reliance upon the services. And again, without understanding how the services were being used and exactly what was being provided, a knee-jerk reaction would be, well, of course you should indemnify me for the services. But because they weren't directly related to the administration of the services, it was an appropriate exclusion. So I apologize for that. I actually gave the wrong example the first time around. That was my limitation of liability example. I'm sorry. Another example is we were working with another client that contracted with a component supplier, and they were making a very sophisticated piece of machinery. The component was simply designed to protect the machinery from the elements. So it's a very inexpensive piece of component. The ultimate machine, if you will, was very expensive and was actually going to provide some very critical services to a hospital. And again, the request was to limit indemnification related to the particular product. Any death that might relate from that. And primarily because the part itself was very inexpensive in relation to the overall product that was being made. However, in talking with the client, we understood, what happens if this product fails? When this product fails, the overall product fails, and if that happens, people may die. At that particular point, obviously, we do need some indemnification, and that was a very heavy negotiation because it was a situation where the exposure greatly outweighed the economic benefits of the supplier, but at the same time, some form of indemnification was necessary. But again, both of those are examples where at first blush, it might be like, oh, you should give me indemnification. Oh, that's okay, you shouldn't. But once you really start to really understand the intricacies of the commercial context, it becomes apparent that either you do or you don't, or you need some type of modification to it. And again, you're going to hear us say this 1,000 times in this presentation about understanding the particular commercial context, because these are they're concepts, and without putting them into context, that, and having a very intimate and thorough understanding of how products are used, the relationships of the parties, they don't make any sense. And you can only meaningfully negotiate this involve difficult issues and topics, the better that I, as the lawyer, can get an understanding of how this is being used in the business and communicate directly and often with my client, the easier it is for us to reach a resolution that's happy for everyone, because you're coming up with commercial solutions.
And just to kind of piggyback off of what Kevin said, the facts are the driver here. And when working with clients, the more we get in the weeds and dig in the details, it's impossible to do this at a high level. You really have to understand the facts, and that's what, we negotiate kind of with our clients, just back and forth about, explain to us how you're using this. Tell us a little bit more. Well, give us the history here. Is there a history with the supplier? That's when you figure out what these provisions really need to look like, the more you dig into those kind of things.
We're going to move to warranty.
Warranty provisions can be another highly negotiated area. A warranty is simply a promise or affirmation by seller that the fact about the goods that constitutes the basis of a bargain is or will be as stated or promised. Article 2 of the UCC, Section 312 to 316, deals with warranties with respect to the sale of goods. 312 to 316 deals with your implied and express warranties, and then 316 permits disclaimers of express and implied warranties. Commercial agreements tend to have express warranties with a waiver of statutory and or implied warranties. In our experience, warranties are traditionally fault-based, which means they're applicable or triggered when the supplier product fails to meet a particular standard. However, as Kevin will discuss later, we're seeing warranty models move from this traditional fault-based to more of a shared warranty model. A lot of our clients are starting to move to that, and Kevin will go into that in a little bit. So let's take a look at, some sample warranty provisions. We have a products warranty example as well as a services warranty example. For the products warranty, we have supplier warrants to buyer that for a certain period from the date of either manufacture, shipment, delivery, or use of the goods, that such goods will conform to the specifications set forth as of the date of manufacture, shipment, delivery. Warranty period defined, and then certain promises are typically made with respect to the functioning and or condition of the product. One commonly negotiated point here is when the warranty period should begin. Manufacturers are going to want the warranty period to start upon the completion of manufacture, where that might not be logical or work for the client because they may order a product and might not use it for 6 months. So it just might sit on the shelf. And so they typically won't want the warranty to start until they place the product into use. And now let's take a look at our service warranty example. With the service warranty, you'll typically have a warranty for how the service will be performed and a warranty with respect to the skill and ability of the service provider. Our example provides supplier warrants to buyer that the services shall be carried out with all reasonable skill, care, and diligence, commensurate with the standard of care of similar consultants performing similar services in the supplier's industry. This is the warranty with respect to how, and that supplier's personnel assigned to perform the services possess the training, skills, competence, and experience necessary to safely and properly perform the services. And this is the warranty with respect to the skill and ability of the service provider. Now we have an example of a disclaimer of warranties provision. You'll notice that the language here is in caps and bolded. This provision provides, except for the warranty set forth, supplier makes no warranty whatsoever with respect to the goods, including warranties related to merchantability, fitness for a particular purpose, warranty of title, infringement against third-party IP rights, whether express or implied by law, course of dealing, course of performance, usage of trade, or otherwise. And here we have another one of our risk alerts. The thing you want to remember here is, again, related to the facts and circumstances. Where parties have a history of dealing, and warranties can be implied based on past conduct or usage. And you want to make sure that there are instances where you want to waive, that you want to make this implied warranty, and there are instances where you don't. And without knowing the facts and circumstances, you don't want to inadvertently waive an implied warranty that you shouldn't have, or vice versa. Next, we have common warranty remedies. They include the 3 R's, repair, replace, refund. A common negotiated point here is who gets to decide which warranty is applicable. Suppliers will often want to have language such as at supplier's sole discretion, and buyers will want to have similar language. So a lot of times, you know, we go back and forth on who decides which which remedy is applicable.
Managing the risk with respect to warranty provisions. Again, I guess one of the first things that the parties want to ensure is that the warranty tracks the bargain. And that kind of goes both ways. What was promised? The customer wants to know that the product or the service, that the product will be manufactured, delivered in the state that it was promised, and the supplier doesn't want to warrant for anything other than what it specifically promised. Often there is a reference to capital S specifications or capital of the product should contain. Oftentimes, for example, if it's the supplier's published specifications, there's a question about it changing from time to time, and the notice provision. But ultimately, it kind of goes back to the bargain. This also relates to another point that might be a whole nother CLE, but I'd like to highlight is that a lot of times, especially with consulting agreements are very good about specifying what you pay and when you pay and nothing else. It's hard to determine what you're supposed to get, what it's supposed to look like, and when you're going to get it. So if your agreement doesn't do a very good job of describing what you're going to get, your warranty is not going to have much meaning. So you got to really understand what the basis of the bargain is with respect to the condition of the product that's to be delivered to even begin to negotiate the warranty. The second point I want to highlight is ensuring that the remedy is appropriate. As Tiffany alluded to, oftentimes there is a discussion about who gets to choose the remedy. And at first blush, you might think that if a customer receives a refund, they're fine. Well, no, oftentimes they're asking for a very unique product. They want the product. They are willing to give you the money for the product. They need the product. And again, if that's the case, we need to make sure that we've got some protections in there. In addition to, making the warranty, maybe you remove the concept of refund and you actually put some time constraints around the replace and put a very structured process with respect to notification, response, and the time to make the repair, to make sure that the client is getting what they need when they need it. But again, just working at this at 1,000-foot level, you won't understand that unless you take the time to understand really what's at the heart of this particular product or this contract. In the course of dealing, again, what I have seen over my career, small company, large company, it doesn't matter. Most recently, I was working with respect to an agreement between two parties that have been in a relationship for 8 to 10 years, both, Fortune 150 clients, and they had an informal warranty process, in effect. So that, my client told me, hey, when something happens, I just call Jack. And I say, Jack, something's wrong, and he sends me a component. Well, that's the way they've done business for 8 years. If you've got this waiver to course of dealing, uses of trade, that goes out the window and you can't enforce it. And that becomes one of the things I like to highlight to my clients is that everyone at the table today might not be at the table tomorrow, right? But if you can document that this is the way you've done it, this is how you rely on getting business done, that's a valuable history, and that's a part of your relationship. You want to preserve it. Another item that we should really take time to understand, again, is when the warranty period begins. And again, Tiffany talked about this. Oftentimes clients will buy, especially when you represent a manufacturer or a hospital that's buying a lot of things at one time and they sit on the shelf. Well, I don't particularly need the warranty period when it's sitting on the shelf. I need it when I pull it off the shelf, when I put it in the service, as Tiffany highlighted. And a lot of times, at the same time, the counter to that position is that the supplier needs to kind of put a finite window on their exposure at the same time. So again, it's understanding, taking the time to how do you use it, what's the history, and once you really need the dough, again, the palatable compromise often presents itself. Recent development here, I want to talk about the shared warranty model. Again, historically, it isn't what it's supposed to be. I, as the customer, send you some type of notice, let you know that it wasn't what it was promised to be. You get back to me, I send it to you, you test it, no trouble found, RMA process. And what we've seen, especially with clients who are the manufacturers of durable goods, where they have a number of component suppliers, they put something out there in the market, their customers have a problem and they repair, that particular process has been inefficient. And as a result, those clients have been absorbing an unfair allocation of the warranty expense. And a lot of those clients are moving to a shared warranty model. And it's always interesting when a company decides to take this process because the counterparties react, I guess, adverse. I don't even know how to describe it. It's a bad reaction. I mean, it's the first time it comes out. People have a hard time understanding why they should pay for any warranty expense where it hasn't been conclusively determined that they're at fault. It's just unfair. And again, our job as the lawyers is to kind of point out a couple of things. One is that even with this process, both the customer and the supplier's interests are aligned. Oftentimes what we see is that the customer will actually incur warranty expenses and submit them to the component suppliers on a quarterly basis. And 9 times out of 10, what it entails is that the end user will come in with a problem, the customer will diagnose the problem, make the repair, and they kind of flag it, like, oh, this problem relates to this particular component, and they kind of aggregate them. And then there's a predetermined allocation in the warranty agreement or exhibit. Sometimes, so there's a higher percentage if the supplier designed a particular component, but if it's an off-the-shelf component, there's a lower percentage. So what happens is that over the quarter, you'll make 9 repairs over the quarter that relate to this particular component, and you'll send an invoice for reimbursement at the end of the quarter. Well, under that scenario, the customer is actually incurring an expense. So they're just not willy-nilly throwing expenses over the fence for you to reimburse. They're actually making an outlay of cash. Secondly, what I like to highlight to the other side is that without the end user, we don't have a product, and I have no need for your component, right? So keeping these customers happy, because the other thing is that, well, you're being overzealous in keeping your customers happy. How do I know that you're just not repairing every this relationship? So again, our interests are aligned. The most useful tool that I've had is that, especially where clients are very good with keeping historical data on warranty claims with respect to particular suppliers, even at the part level, pulling the warranty data, the historical data for 2 or 3 years. And oftentimes what we see is if you can pull the warranty claim data for 2 or 3 years and then kind of plug that data into this model, oftentimes the delta isn't too great, and that gets suppliers comfortable. And I'll often remind them that, again, this is a warranty issue that we're talking about, and you're in the best interest to ensure that your product is not failing. So this is you're in the best position to avoid this overall. But in circumstances where there is a great delta, oftentimes it's been a situation where that particular supplier has benefited unfairly from the inefficiencies in the traditional warranty model. But again, I have seen this as something that I've seen more and more with clients. I've seen it with at least 2 or 3 clients in the last 18 months. And it's interesting to negotiate. So, but again, you can't negotiate. Again, it's consistent with the theme that you've heard me say probably 30 times in the last 20 minutes, is that you really have to take the time to intimately, as a lawyer, to intimately understand what's going on with the commercial transaction. Because otherwise, you're just going to hit a brick wall where there's no way I'm going to pay you for something that I didn't do. And so once you kind of understand it and understand the business perspective, you can sell this to the other side.
Okay, let's take a look at limitation of liability. LOL provisions are an important tool for defining the scope and magnitude of the party's contractual liability. As Kevin alluded to, we typically see a lot of negotiation here when the commercial reality and the risk allocation are out of sync. And he used the example where the part doesn't cost a whole lot, but the liability and potential risk associated with the use of the product is substantial. So the LOL provision can allow you to bring the risk and allocation more into sync with the commercial reality. LOL provisions are not always necessary. You really do have to consider the facts and circumstances to determine whether it's necessary to bring the risk allocation into sync with the commercial reality. LOL provisions, like indemnification provisions, can be unilateral or mutual. Okay. There are 2 common types of limitations. The first is a limitation with respect to the amount of liability. We'll often see caps on the amount in the form of either a fixed dollar amount, the amount covered by a party's insurance, or fees received under the contract over a certain amount of time, such as 1 or 2 times the annual contract value. The caps limit a party's exposure to a specific agreed upon amount and helps to provide certainty. The second type of limitation is with respect to the type of liability. A common exclusion here is consequential damages. And this is a big one. We have seen a number of times where our clients will just agree to waive consequential damages as a matter of course. We highly discourage this because, as we noted earlier in the presentation, consequential damages must meet the foreseeability, causation, and certainty requirements to be recoverable. So if you can meet these tests, then you should be able to recover.
Yeah. Just one thing I want to add there too, again, like Tiffany things that I highlight for the business folks is that, one, there's two kind of buckets of exposure that we're generally worried about. One is that if the supplier's late in getting us the component, you have to shut down your production line, or does it disrupt your production process? And if the answer is yes, then we need to delve a little deeper, because that could be a significant expense depending on the client's circumstances. The second sphere of exposure that we're worried about is what happens if the product fails? Does it directly kill someone? Does it require you to rebuild the product that you're building? And what does that cost? And to kind of, depending on the answers to those questions, dictate whether or not, one, we should look into retaining the consequential damages. Once we decide that, and oftentimes people, again, because out there in the market, not only do I see clients just as a matter of fact waive it, I see other people on the other side just say that there's no one, you know, this is common to waive this. Everyone does it. But the problem is, what I explain to the business folks that I work with is that if this becomes a problem, people in your organization are going to have the benefit of hindsight 2020, right? One of the tests is that it has to be something that was anticipated when you entered into the contract, right? So if this happens later and someone is looking after the fact, it's like, well, how could you possibly have waived consequential damages here? It was clear when we started the agreement that this is going to be an issue. So, you know, so again, one, I point out that this is your real exposure. These aren't just words on the paper. This is what this means in real life. Secondly, this is what this means in terms of your role in the organization, how you're going to be evaluated. And again, as lawyers, I think that's our job, because often the business people kind of see us as the obstacle to getting the deal done. And you're just arguing about the concepts that don't matter. And again, I think that, you know, my job and all lawyers' jobs is to, you know, especially in an instance like that, is to educate the business person as to why this is important, not to this only to this particular agreement, but also to their role in the organization, and ultimately their compensation, and how they'll be perceived by their peers.
I think a lot of this happens because people rely so heavily on form agreements. And so they take something that was used in a prior deal and they just roll it over and change the name of the parties, et cetera, without really diving into these provisions. And whatever made sense in the last deal, because these things are so fact-driven, might not make sense here. And we see that a lot. You know, it's like, well, this doesn't even apply, but the last time this document was pulled out, it applied. So it's clear that nobody kind of really dug in to figure out what it needs to look like for the current transaction.
And on a related note, this is probably more a point out why we did something in this agreement that we didn't do in the last agreement. The better they become and the less we have to do. And also probably the most fun part about my job is when I can articulate the exposure and why it matters to them. Then when we get on the phone with the other side, it's lovely because they just kind of start off. And I don't have to say anything, right? But again, I think it's a two-way street. Like, you know, it's our job to understand the commercial context, and it's our job to educate the business people with why it matters. And when you do that, you get a good contract, you get a happy client, and you talk less on the phone.
Mm-hmm. It's true. So common carve-outs to LOL provisions include third-party claims arising under the indemnification provisions, breach of confidentiality claims, IP infringement claims, and claims based on gross negligence, willful misconduct, or fraud. And the big risk here is just the failure to include these carve-outs. There are some things that are appropriately capped, and there are other things that you just want to make sure you did not inadvertently fail to exclude, such that the cap applies.
Oops, sorry, I'm bad clicker today.
That's okay. I'll quit. So we have another sample provision, an LOL provision, and I have color-coded it as well to help you see the various parts. Our carve-outs are in red. These are the items that are not subject to the cap imposed by the provision. That includes indemnification, breach of confidentiality, and third-party IP claims. Again, these are kind of some common carve-outs. The blue language is the cap on the amount of liability, and it provides in no event shall the applicable party, this can be mutual or unilateral, the applicable party's aggregate liability arising out of or related to this agreement exceed a certain amount of the total amounts paid to supplier pursuant to this agreement over a certain period preceding the event giving rise to the claim, or a certain amount, whichever is greater or less. And the bracketed language just indicates that there are options and various ways of tailoring this language. And then the purple language is our waiver of damages. In no event shall the applicable party be liable for consequential, indirect, incidental, special, exemplary, punitive, or enhanced damages, lost profits or diminution in value arising out of or relating to and or in connection with any breach of this agreement, regardless of A, whether such damages were foreseeable, and this is getting at consequential damages, B, whether or not the applicable party was advised of the possibility of such damages, again, this is getting at consequential damages as well, and C, the legal or equitable theory, contractual or otherwise, upon which the claim is based. This is kind of the kitchen sink, and it can be tailored appropriate. It should be tailored appropriately to fit the applicable circumstances.
Under managing risk under limitation of liability, one, I kind of going back to the waivers, those are the common waivers. With respect to waiving indemnification, 8 times out of 10, that's probably a solid idea. That example, but there are certain ways. There are some situations that indemnification, to some extent, maybe it should be subject to the cap. The big thing with the limitation of liability too is that you need to really look at the entire agreement, not specific damages or exposures. This is again, all of these tools are allocation of risk, but this limitation of liability kind of interlocks with all of them. As Tiffany indicated, that this LOL provision, I wouldn't call it standard at all. I would probably say most agreements don't even have a limitation of liability provision. They apply in particular circumstances, normally where again you've got this disconnect between economic value of the contract at hand and the subject matter of the contract, if you will. Again, so in fitting it, you need to kind of walk through. Does it cover just certain parties? Is it just one party that gets covered? Is there a dollar amount? With respect to the actual amount of the cap, oftentimes where clients will have a policy that it will be a multiple of the contract value. And again, you really need to kind of look at that. In the example that I'm going to give you under the appropriate circumstances, you're going to see how this was out of whack. But I will say as a general rule, if you're not getting at least 1 or 2 times the contract value, if the limitation of liability provision is appropriate, you really need to look at that, because exactly what kind of coverage are you getting, to be honest with you. I have seen instances where people decide like 0.3. I mean, like, what is that? I mean, honestly, what is that? Seriously, what kind of coverage are you giving me for that? The other thing is that, again, it's the commercial context, and it's all the other provisions that you've negotiated in the agreement. You have to take a look at and see how these things all hang together. And then kind of a no-brainer is that it's got to be clear and bold. It's got to be unequivocal, bold language, all caps. But the limitation of liability should be very easy to understand. It should be very clear what you're limiting, what you're not limiting, and to what extent you're limiting. So the example I want to give, again, is the example where our client was contracting for the valuation of its real estate portfolio. Originally, there was no indemnification, but that wasn't the point of the story. We got indemnification included. The service, so again, not going to make a mistake on every parcel, but if they make a mistake on a handful of parcels, this is easily a $50 million problem or even a $100 million problem. I think the service is a 6-figure number, right? So they wanted to cap it at the cost of the contract. So, a 6-figure cap doesn't give us much protection if they even make one mistake on a parcel of property. If they make a mistake, a mathematical mistake, we in turn use that, because you got so many properties, no one's really, at some point you're just relying on the numbers. You get the numbers to the broker, you get the insurance coverage. If you get improper coverage, you suffer a casualty loss. You don't have appropriate insurance coverage, that could be significantly more than $100,000 or whatever it is. So in talking with the client, first I had to kind of talk them off the ledge that we don't want the service provider to be the umbrella insurer either. We certainly don't need an uncapped indemnification. That some cap on indemnification in this instance is appropriate. And I agree that 6 figures is definitely not enough. But at the same time, kind of what that number is. And kind of working with the client, we came up with a number that was, I think, maybe 50 million or something like that. The consultancy came back and said, our company policy is we don't give any more than 5 million. These are numbers are examples, but they're pretty close. In any case, after several rounds of, pretty intense negotiations, it was clear that that was not acceptable, and we really needed them to move. And ultimately, the business people from the consultancy actually went to the C-suite of this major consulting firm to get an exception, to get a cap that was closer to that $25 or $30 million threshold. But again, that, and no one really saw that coming in. That was just a kind of a function of, at first you see, even, you see the contract, oh, these are valuation services, but the more questions you ask, the more you get involved with the client, understanding how they're going to be used and kind of really understand what's going on, you get there. I mean, and in that particular instance, that was, I think the consultancy was certainly surprised because, some of these consulting firms kind of, we just don't do that. And it's like, well, I'm sorry, maybe no one's asked you the right questions, but I mean, once you kind of characterize it and you define the risk and you define it under commercial terms of what you're providing, we're relying on you, you're saying that we shouldn't rely on you, it starts to make commercial sense. It's hard to walk away from it. And ultimately their C-suite agreed with the working group and came up with that result. So, questions?
Hey, Kevin.
Yes.
This is Chris Combest out in Chicago.
Hi, Chris.
For those who don't know me, I'm a partner in the bankruptcy and restructuring group here in Chicago. I'm here with my partner, Jennifer Zucker, in that group as well. This is more of a comment, but I'm going to phrase it in the form of a question. Do you, when you work on these transactions, do you typically think in terms of, or do our clients ask about the effects of an insolvency down the line? In particular, from what we've seen in our group, if we represent the supplier and the customer might go into bankruptcy, provisions that address, for example, the ability to alter payment terms from, say, trade terms to cash on delivery or cash in advance if the customer falls behind, or even you said getting into the weeds. If you get into the weeds enough and understand the client's business enough, there might be a situation where retaining a purchase money security interest in the goods would be important, or waiving the automatic stay in the bankruptcy. If we represent the customer who's worried about the supplier going into bankruptcy, do you think about resourcing rights and the right to obtain, product that's already been made for us and maybe been repaid for, but is in the possession of the debtor supplier? These are all issues that have come up in various situations for us. And I wonder if you think that's worth addressing in some of these agreements.
Yeah, I agree with that. I think it's on a case-by-case type of basis. And again, it's after kind of having the contextual conversation with the client. In the same vein, I've seen situations that kind of deal with that insolvency issue with respect to last-time buy provisions, the ability to assist in sourcing kind of specifically designed parts from other folks, and assisting and facilitating some licenses of IP and things like that. And, again, kind of as kind of tongue-in-cheek, most times when I have those issues, I usually call you, Chris. Anyone else?
I haven't seen where they have used you guys mentioning a carve-out or using the warranty as a carve-out for limitation of liability. Can you comment a little bit on that?
Using the warranty as a carve-out on the limitation of warranty. Oh, yes. Yeah, absolutely. You're right. That was actually an oversight. In fact, that was negotiated in agreement not too long ago, because especially under the shared warranty model, because that blows the whole point. The whole point is that no matter if there's a warranty claim that's involving that particular component, the warranty should be covered, no ifs, ands, or buts. And you're absolutely right. Yep, that was an oversight. Good catch.
Another question that I have is you mentioned design warranty, around design warranty. Design warranty is heavily negotiated.
Yes.
And there's like a kind of a catch-all. So can you talk a little bit about that?
Sure. A lot of it depends on kind of, again, the roles and the expertise of each of the parties. To what extent we are relying on the supplier's expertise in IP, not just the kind of the technical engineering or kind of nuts and bolts, but actually the gray matter and coming up with it. situations. You know, just because I, as a customer, say I want the stylist to do certain things in a certain particular way, I'm relying on you to figure out how to do that. I'm also relying on you to tell me that, you know, this could be harmful to someone, or that if you do it this particular way, this is going to cause an infringement issue. But again, I don't think, as with all of these risk allocation tools, I don't think there's a general rule. I think that you need to understand exactly kind of what the roles and expectations of other parties, and then allocate the risk accordingly. And with respect to design indemnification issues, or design in general, I often work hand in hand with an IP lawyer specifically, because again, as you said, they're heavily negotiated. You have no choice but to get neck deep in the weeds with that. And oftentimes you need someone who is an IP attorney to be involved, because quite frankly, most of them are also engineers. And as me just being a regular attorney, I don't understand it well enough to get into the weeds that deep without someone that's an IP attorney with an engineering background. Sure. Yep. Yeah, but I guess in my mind, I'm thinking exactly. Yes. Anyone else?
I have a question. The indemnity funds I've seen usually start off with 3 funds. Then indemnify. Let's say I made that promise to your client, and he filed suit. He files 3 counts. I mean, defend, one failed to indemnify, one failed to hold promise. And I believe you failed to litigate damage. That defense, I think, is good for count 1. That failure to litigate damage, is that been waived by the Congress?
So the hold harmless language and the indemnity language, I think everyone knows in law school that there's a duty to mitigate, like particularly in all cases with respect to damages. And with respect to the hold harmless and the duty to indemnify them for the loss, I think it's arguable that it's arguable that mitigation or that lack of mitigation would not impact that particular provision. I think there's an overall duty as a general contracting principle that there's a duty to mitigate. I think that's just general legal American jurisprudence.
I understand that's contracts. One, I'm not.
Can you contract that out?
To hold somebody harmless if you didn't waive some of your contract law defenses.
I haven't seen case law, and to be honest with you, I haven't thought about it that precisely. But I'm certainly I'll think about it tonight before I go to bed.